All right, Rowena, why don't we get started here? So thank you everyone for joining the webinar. Both Rowena and I are happy to have you guys here. Obviously, we're going to be speaking today a lot about privacy compliance and particularly the value of working with Didomi and partners like IAB and the GPP framework. So just a few housekeeping items. You can use the chat on the right side of the screen to communicate with us. There's also a questions tab. So please feel free to ask questions along the way. I think both Rowena and I would both love to have more conversational than just presenting to you guys slides. And the more interaction we have with the audience, the better. So feel free to use those. We will have a couple polls popping up, which Clara on the Didomi side will share as we kind of go through the presentation. So just by way of introductions, my name is Jeff Wheeler. I'm the Vice President of Product at Didomi. I've been here for about 3.5 years. I've been in the privacy space for probably longer than I care to admit. But I'm really happy to be here and spend some time with you guys today. And that being said, I will hand over the mic to Rowena to let her introduce herself.
Hello, everyone. I'm Rowena Lam, and I'm the Senior Director of Product for Privacy and Data at IAB Tech Lab. And I lead our privacy pillar. So any standards that can help the industry comply with global data privacy regulations is sort of in my wheelhouse.
Thank you for that. So the agenda today. So we're going to go through. You're going to hear a lot from Rowena today. She's the real expert here on GPP. But we want to spend some time going through, the background, the timeline of GPP. What the impact on the framework will be, and some real world use cases that we've seen recently in the space. And then how to adopt GPP to better collect cross regulation consent. I think everyone here would agree that the multi regulation consent that we're living in today is quite complicated and complex for everyone to solve. So, a little bit about Didomi for those that haven't met, is we are a global um, privacy platform specializing in user choice, scanning of websites, preferences, data subject requests, so forth and so on. Recently in the news, you may have also heard that we just merged with SourcePoint, a US-based CMP. We're really excited about this. It's going to help us leverage, more of our expertise, in some key markets for us. So as we go through today, if you hear us mention or hear me mention SourcePoint, just wanted to throw that out there that, SourcePoint and Didomi are now one company, working together to offer, bigger, better privacy solutions. So there's my quick spiel about us. Context and timeline. I think Rowena, I'll hand over the mic to you, and she can handle these next couple slides. Again, feel free to please use the questions tab, and then I believe Claire will be sharing a poll as we speak about everyone's familiarity with GPP. If you guys can please spend some time on that, that'll allow both Rowena and I to kind of tailor the conversation more appropriately to the audience. So Rowena, off to you.
Thanks, Jeff. So maybe I'll start with a little bit about the Tech Lab, in case there are any folks who are not familiar with the IB Tech Lab, and then I'll also talk about why we embarked on this journey of developing the GPP as well. And so Tech Lab, we are a member-driven consortium with over 1,000 global companies participating in more than 23 working groups on a variety of topics. We produce global technical standards to support the growth of an interoperable private ad-supported digital media ecosystem. And so some of the standards that some folks on the call perhaps you may be familiar with, have heard of, use, that the Tech Lab stewards includes things like VAST, OpenRTB, appads.txt, and TCF, the technical specifications, and of course the GPP, which we'll be talking quite a bit about today. So I lead a privacy pillar at Tech Lab, and so why did we embark on developing the GPP? Data privacy regulation wasn't necessarily a new concept, but as more and more jurisdictions began to revisit those regs to account for the digital world that we now live in, it was becoming really clear that if you were going to make use of personal data in digital media, there were going to be certain legal obligations and rights that need to be afforded to consumers. And we saw that attempting to manage this at a global level was going to be really challenging for businesses because started with GDPR, then we had CCPA, and now it's exploded from there. Each regulation was pretty nuanced. So it's really complex today. There's a stat, it's like more than 80% of the world's population already lives in a jurisdiction that has a comprehensive data privacy regulation. And so that's sort of the why. And this map like only, I would say, like touches upon what I just said. It's 80% of the world's population now lives in a jurisdiction that has a comprehensive data privacy reg. And so what is the GPP? The Global Privacy Protocol, or GPP for short, what it is an adaptable channel agnostic protocol for signaling user choice in the ad supply chain. And we call it the Global Privacy Protocol because the vision for it is that it will support consumer choice signaling for any jurisdiction that has data privacy laws. And we specifically, in the development of the protocol, wanted it to be adaptable and flexible so that it can account for those nuances in regional privacy laws while also still maintaining a common technical architecture. The idea is that, as this becomes more complex, the industry needs a sustainable approach that wouldn't require global organizations to start from scratch each time they needed to comply with some new data privacy regulation. So the evolution of the GPP, I'm not going to go into a ton of detail, and this is not necessarily comprehensive, but a few things to highlight. I can't believe I'm saying this already, but GPP is already a few years old at this point. So it's a few years since the initial launch of the standard. And since the initial launch, there have been a few updates. We have continued to add support for additional regulations, a lot of them being at a US state level because it's a fun time in the US right now, I guess is what I'll say. But not just that, we've also made some updates to the standard that hopefully provide more clarity for implementers. We also renamed the GPP earlier this year. It was originally the Global Privacy Platform, and we've renamed that to the Global Privacy Protocol because there was some confusion about what the GPP was, in that some folks actually were coming to Tech Lab and thinking that we offered at the Tech Lab a SaaS product. And this was some sort of like privacy management platform. And so hopefully the renaming of it provides some clarity that this is a technical standard, it is a protocol, it's not a SaaS product. The other thing we did was we released implementation guidelines that provides those who are perhaps new to GPP a place to start and get familiar with the protocol. And then I'm sure a lot of folks might be wondering, well, like, what about the future? We are, of course, looking to continue to add support for additional regulations. And we actually just released for public comment a specification for yet another US state specification. Specifically, it's for Minnesota. So that is in public comment, and we welcome feedback on that spec. The Global Privacy Working Group, which is the group that stewards the standard, is also working on some additional enhancements to the protocol, which we do aim to have out for public comment in the next few weeks. That is all to say that this is a living, breathing protocol, and we're constantly trying to make it a bit better based on market feedback. And so just to get, I would say, like, some of the key things, and maybe, I don't know if we have poll results at all.
Yeah, so we do have some poll results, Rowena. It's pretty interesting. I think everyone either understands the basics or they've heard about it, but they're not sure exactly what it does. And so I think maybe in this next section, we'll be able to delve into both of those.
Perfect. Yeah, that's super helpful context. And I do hope that the next couple slides will help solidify what it does and how it helps the industry. And so the first thing that I want to call out is that it is a technical protocol. And what this means is that GPP provides privacy signals. I think I say privacy signals quite a bit. You hear that term used quite a bit, just broadly in the industry. And so I thought what would be helpful is like define that a little bit as well. And so when we say privacy signals, what we're essentially saying is that privacy signals are a representation of a consumer's choices as it relates to the collection, processing, sharing, selling of their personal data. And within the GPP, what we do is we use strings, encoded strings, as a representation of those choices, which then makes them machine readable. And so GPP, it includes technical specifications that define how to encode a signal. So to take those users' choices, create this string that can be read by a machine. Um, it defines how to decode a signal as a recipient, how you can read that string to understand what the user's choices are, and then also how you ultimately find a signal. We do have resources for the industry like open source code libraries and a string encoder and decoder available for implementers to help with implementation. And the thing I also always like to highlight is that what the GPP is not is it is not a privacy policy. The GPP alone does not define policies on what must be done when those signals, which again are, you can think of them as representations of what the user's choices are. Um, GPP doesn't define what must be done when those signals are sent and received. So I talked about implementation guidelines, and the implementation guidelines actually talks about this notion of core versus sections a little bit, just for those who are maybe a little bit less familiar with the details of the GPP, like how do you actually navigate reading the specs. So just to go a little bit deeper, I think it's helpful to think about the GPP as having almost kind of like two top level categories. The first is there's core, and what is in core. There are technical specifications for the CMP API, and then there are technical specifications for the consent string itself, the string being the privacy signal, which is a representation of those users' choices. And so these are the pieces that remain common regardless of the jurisdiction that we're talking about. And so the API is the portion that defines like how folks can find the string or how CMPs make the strings available. And the consent string portion defines data types that any section could use in their strings. It also defines what's in the GPP header, which I'll get into in a little bit, which stays structurally the same regardless of the jurisdiction. So the way to think about it is the API and I would say the high level consent string and especially the header of the GPP remains for the most part constant. Then the second like high level category are sections, and sections typically represent an individual region regulation. So here are some of the examples of supported sections today: TCF Europe, TCF Canada, California, et cetera, et cetera. And each one of these sections will make use of the core string specification. So each one of those boxes that you see on the screen, CMP API, consent string, TCF Europe, California, they're actually all unique specifications that can be independently updated. So the idea here is like this is what offers the flexibility of GPP.
So, Rowena, I know we're about to get into how does it work. We do have a question. I'll leave it up to you if you want to wait till the end to answer. But Simon is asking, is GPP equivalent to the TCF? An alternative to it? Can it avoid the recent problems that have been met by TC string inside of the TCF protocol?
Oh, that's a great question. And so I guess like the way to answer this is TCF and GPP are two distinct strings today and distinct, they have their own distinct, actually, I'm going to go back to this slide, APIs. And again, if you think about APIs as the mechanism for making available these user choice strings and being able to get those user choice strings, there are two distinct ways of doing it. There is a vision at some point in the future that the standalone TCF CMP APIs would go away, and you could transact using, for all intents and purposes, like the same existing TCF strings that we know today, using GPP specifications instead. So there's a vision for that, and the reason why we're not there yet is because obviously GDPR was one of the first regulations and predated, this I would say like vision and thought that this was going to kind of explode globally the way that it has. And so TCF was the very first. There was an immediate need to address GDPR and e-privacy, and um, we just recognized again that we can't keep doing these one-off implementations, and so GPP is kind of the path forward. But obviously TCF in Europe is very widely adopted, so we recognize how um, challenging it might be to transition, and so we want to be very thoughtful about that before we sort of start encouraging the industry to transition. I'm actually not quite sure about what the challenges were in relation to the TC strings themselves, so I don't know that I can speak to that piece.
Fair enough.
So how does it work? This is essentially what a GPP string is. Hopefully you guys can see that in that like box on the left hand side. There's a header, which I just mentioned previously, that is defined that by that consent string specification. And that can be thought of as a table of contents that tells you what section level strings to expect following that little tilde character, which is the delimiter that we used. So this is essentially what it is, and you can see some of the supported sections today. As I mentioned, we have Minnesota in public comment right now, and then we do have additional states coming online later, I would say like later this year. And we do have other jurisdictions that the Global Privacy Working Group has been discussing, like India as an example, support for India at some point in the future as well.
I think what's an important thing to talk on this, just going back to it really quickly too, is and we'll get into this in the next section, is you look at those supported sections, and I think what this really does is not only highlight the global complexity that we see specifically in the U.S. without forgetting that this is a global string, and not just a U.S. national string, but there's so much nuance between state by state in the U.S. But I think even if you look at something like the EU, and how we have different regulators making different decisions in the EU. Rules that CNIL makes, or the ICO makes, or the Belgian DPAs are making. It kind of drives home the point of having this one reliable shareable string that really simplifies an overly complex use case that we see without or within the industry. So I just wanted to call that out, and we'll talk about that more here in the next section. Um, Here shortly, right? And really, what does the impact of the framework have on the business? Um, so again, it's one framework and shared signals across the supply chain. So here on the next slide, I'll show you guys an example of what we see quite often at Didomi, working with our customers in terms of the complexity of like the third party vendors they're working with, and then you throw in the complexity of things like what we recently saw with Healthline of they had multiple opt-out mechanisms. They were trying to comply with GPC. They were trying to offer opt-outs. They had so many touch points that really ended up failing them. On top of trying to monitor what was going on their pages. And it signals different decisions. It signals the power of privacy decisions, but it also starts showing that signals are a starting point of what we're trying to solve for, as an industry, and the value of these unified frameworks across multiple complex supply chains. So just kind of want to highlight that there real quick. I don't know, Rowena, if you wanted to add anything on any of these, feel free to hop in and give some insight here. But Um,
Yeah, I also should mention, if it wasn't obvious, that I'm not a lawyer, so like I can't like
yep.
take a look at that like Healthline case too closely, but like we mention it because it's one of the like most recent settlements out of California, and I think it's the largest settlement out of California. And the thing I wanted to mention here at this point, Jeff, too, is like one of the things in that case was they were making use of the legacy US privacy signal. So I do want to chime in to say, like, um, that was deprecated in January of 2024. It was developed with just CCPA in mind, didn't um, include like the CPRA amendments. So if I had one message, I would say like we like please stop using US privacy signals. And I can say definitively that GPP is a replacement. GPP strings are not a replacement for TCF, but like GPP is a replacement for US privacy signals. So please stop stop using that. And that was like one of the points in the Healthline case.
Yeah, I think we could go down the rabbit hole of all these different universal opt-outs and what they mean that may be outside of GPP, but in general, right? I think working with um, someone like Didomi who works very closely with Tech Lab to make sure that we're implementing and helping our customers implement these nuances, very closely. I think we'll get to one section of GPP here in a little bit, but you also take the Healthline and GPC, the global privacy control, which in of itself is, a do not track 2.0 from all of us that have been in the space for a long time. And, those signals they're two separate standards that also kind of have to work together. And if your CMP is not providing a signal that can pass that GPC signal down to a GPP signal, we're going down acronym alley here, right? But that just kind of highlights the complexity of why having that this single platform or this single string really helps kind of mitigate the risk. From what we see from things like the Healthline. Claire actually posted a blog article, that we recently just posted. And I think it's important as you look through some of that as well, because, as you're talking about the complexity of the strings, there's different data types. What's sensitive in one state is not sensitive in another state. What's sensitive in Europe is not sensitive in the U.S. Um, and this single string, again, just to reharp on why it's important to have this, is really highlighted by that. As we hop to this next slide too, I think it's really important. This is one of the tools that we provide here at Didomi is also our ability to monitor, what is happening on a web page. And so, we looked at some of our websites that we've scanned. And this is an example of like the third parties that are happening on a web page. And it's quite, I don't know if alarming is the right word, but it's quite telling to see, how many third parties can interact and share data, and where those gaps in something like that Healthline ruling, where if something is not being opted out to correctly, or they're not receiving the correct signal because, they're daisy chain 3, 4, 5 layers deep, it exposes a lot of risk, to the industry as a whole. It can make us look like not necessarily the best players, but if you're working with the right organizations, the right protocols, the right signals, it allows you to make these complex use cases much more simple, and straightforward, and then monitoring those forward, making sure that vendor A is recognizing an opt-out signal, vendor B is recognizing GPC, that the GPP string is being able to correlate between those is really important, as we move forward. So this concept of vendor management becomes such an important topic, to work in parallel with GPP and all these protocols. Let's see. I apologize. My internet's a little slow here. So, the benefits, for you. We're talking about this, and we'll just kind of re-highlight here a couple of these, that Rowena and I will kind of talk through a little bit here. Expanded multi-regulation coverage. We're going to see this for the foreseeable future in the U.S. I think everyone would agree. There's no light at the end of the tunnel for a federal privacy law that we see right now, and so we're going to keep seeing the state-by-state approach, and it's going to make the complexity of complying not only with the U.S. laws, but we've got Law 25 in Quebec. You've got European, GDPR and the constant changes that we're hearing there. And so, it's expanding the support for that. It's working on time savings, presets, guidance, navigating through the requirements, and then giving you better control and flexibility to make sure that to to Rowena's point, neither of us are lawyers, right? Our job is to give our customers and our partners in the industry the tools to become compliant to how they understand and how they interpret the law. Rowena, I don't know if you had anything added you wanted to add on this one.
I think we're gonna like move into GPP integration
Yep.
actually to just I'm gonna kind of reiterate some of what you're saying as well. Like the idea here is to offer the industry a sustainable and efficient way to manage the global data privacy regulations. So GPP is when we talk about efficiency, I am talking about technical efficiency. Like to your point, Jeff, like we are not lawyers, and I already mentioned GPP doesn't define policies, and so there's still plenty of work for the lawyers, still, right? Like to determine exactly what happens after the signals, which is why, like as Jeff mentioned, signals is the starting point. You get signals, and then you have to do some things. Whether that is thinking about your vendor management, as Jeff was saying earlier. But GPP, like I see it and the way I like to describe it, is the starting point. The benefit here is really the technical lift. There is a technical lift on your first implementation. However, the idea is that on a go forward basis, as you think about more regulations that you have to comply with, at least the user choice and signaling piece of it does not require a heavy lift every single time.
All right. So again, just encourage you guys to ask questions. I know this is there's quite a bit here that we're going through. Um, right. So how can you adopt GPP to better collect cross-regulation consent? It's a topic we've been talking about multi-regulation, cross-regulation, um, kind of working on different terms, and so um, at least from Didomi on how we've solved this is we look at this as there's a much more advanced solution, and there's a more of a pre-configured solution. And so, U.S. notices, for example, with GP, you can be pre-configured, for an automatic mapping of purposes and SPI. So, if you're setting up a California string, for example, you could just simply, set up a share or um, cell mapping. In terms of like a full customization, and I'll show you a graph here on the next slide. You can do your own mapping to what those purposes may be based off of, including things like SPI or sensitive data processing. There's two approaches that we see, and this is where I'm gonna softball a question at Rowena, because it's something that we saw quite a bit during the working groups. Right? Is what we see in the market in particular is there's still quite a mixture of companies coming in and just saying, hey, I'm going to set up, for instance, CPRA nationally, or I'm going to set up, a state by state approach. And what that really led us down to was, what is the MSBA national string or the state string? And so maybe, Rowena, if you want to spend some time explaining the difference between the two, it's been quite the hot topic in the working groups themselves.
Yeah, I'm definitely happy to clarify that because we do get this question quite a bit at Tech Lab as well. So this is very specific to the US, but as I mentioned, since GPP is a technical signaling framework, there is typically some sort of policy framework associated with some of the sections. In TCF, as an example, you have both the policies, which IAB Europe is the managing organization of, and then you have Tech Lab who's stewarding the technical specs. GPP actually does support TCF Canada, for example, as well. The technical specifications are stewarded by Tech Lab, but the policies are stewarded by IAB Canada. And in the US, it's not quite a policy, but what we have is something called the MSPA, and that is short for the multi-state privacy agreement. And so, as it sort of hints at, is that in the US, what we have is this is a spring-in contract, and it defines terms, and the contract comes into play as it follows the data flows. Um, So for those who choose to become MSPA signatories, first parties have the option of deciding what approach they'd like to take. They can either take, as Jeff just mentioned, an MSPA US national approach, or they can take a state by state level approach. Now, we don't have a federal privacy law here in the US, so what does it even mean to take a national approach? Well, the MSPA has provided a framework that says that you can take a national approach by assuming every state law applies, and therefore you must operate in the most restrictive manner. There are pros and cons to this, right? Because it can be simpler from, I would say, like a management perspective. But if you are taking the most restrictive approach, each of the state laws are nuanced. You might be, more restrictive in a state where you don't necessarily need to. And so there's been a question of like, okay, well, why doesn't everyone just make use of the U.S. national, strings and take that approach? Um, and the thing I will say is that it's very important, and not to keep like pointing back to the Healthline case, but the Healthline case sort of points to this as well, that because a national approach, again, is we don't have a federal privacy law, it's pretty important for folks who are looking to make use of the MSPA US national approach that you are a signatory as well, because the MSPA is the thing that defines what you can and cannot do in terms of data processing and what the most restrictive approach actually is. That is different from a state level approach where the state level strings are directly tied to individual state laws. And so there's no ambiguity there. Like there's no discussion or argument about, your interpretation, Jeff, of what is most restrictive versus, my interpretation. It's just what the law says. So hopefully that offers some clarity.
Yep, very helpful. Thank you. So just really quickly, so deploying GPP into Didomi, like I said, we've got really two approaches here. We've got a simplified approach where you're just going to add a first-party vendor to the regulation. You'll enable GPP. We'll apply the mapping by default, just based off, our own vendor database. You configure the MSPA if that's something you're using. You save and test and deploy. Very simple approach, and gets GPP deployed quickly. The second approach that we look at is the more advanced approach, and this is where we see more advanced use cases, and it's generally where I think the market is going, as we're looking at better interactions with the consumer, for instance, is deploying GPP in advanced manner. So it's setting up your vendors, which can be related to your purposes and categories. You can add each vendor to a regulation. For instance, you may have sensitive information in Virginia that's not sensitive in California, kind of like I mentioned before. And so it allows you to configure those in the correct way to make sure that the right information and data is not being lost or is being shared correctly. You enable GPP, and then you map the purposes to the GPP signal per regulation. Configure the MSPA and save and test. So, both are very, they're somewhat new solutions on the market, and we'll continue to work with Rowena in particular and Tech Lab, to make sure that new regulations are supported within the platform. But it allows you to have that flexibility, moving forward. And then lastly, right, I said, GPP is in a template, kind of like I mentioned on the advanced screen, or the advanced the setup, right? So you can map consent purpose to signals that are supported by the regulation of your choice. Again, this is where it's really valuable to work with the CMP like Didomi to make sure that you can set up national strings, you can set up state level strings, global strings, but then also you can recognize things like universal opt-outs, particularly GPC enabled, and make sure that the proper GPC signal can be passed. I know we've kind of focused a bit on Healthline, but if you look back at some of the other rulings, Sephora, Honda, etc., and even some of the other rulings in Europe, when cookies are fired, or when tags, beacons, pixels, etc., are fired, and consent is not associated with it, it's the big red flag that they're looking for, right? So this is the type of setting these templates up will make that idea of adding new vendors, purposes, etc., onto your website easier to manage in the future. And I think that is coming up on our last slide. So went through pretty quick. We did want to make sure that we left plenty of time for questions. I know being a lot of our Didomi customers are European focused, there's probably some uncertainty around it. So, if you have questions, please post them up now. Rowena, I'll take a few minutes to make sure and address what we can. So let's see what we have in the chat. Give people a few minutes to post up. All right, so let's see. What is the process of adding additional regional signals to the GPP? Is the first question we got, Rowena.
That is a great question. And so since we at the Tech Lab, we do not, I would say, translate laws. The way that the process starts is we will always need some sort of requirements in terms of what are the specific user choice signals that must be communicated. And that's kind of like the starting point. So I get this question quite a bit, or like folks will come to Tech Lab and say, hey, can you please, introduce a new section? And my answer is always, it's not quite as simple as that, because we're not on the Tech Lab side, again, doing the like legal interpretation work of it. And so it always starts with getting legal requirements of what needs to be signaled, what are the user's choices, and from there is based on those requirements is how we can then kind of translate those legal requirements into technical requirements to introduce a new section string that helps with communicating the user's choices for that particular region. And as I mentioned, like sections in GPP are typically representative of a specific like region's regulation, sometimes with an S, because if you take a look at TCF, it's e-privacy and GDPR. So it just depends, but it's typically for a specific region. And we at the Tech Lab, we do have a process for evaluating proposals for additions of user choice signals for a specific jurisdiction. This protocol is really meant for compliance with regulation and not, I'll say, like self-reg per se. So that's kind of like the line. So it's kind of two things. Like one, we need the legal requirements, which then obviously means that they have to be tied to some sort of like specific regulation, and not just because the domain, you guys have a perception on what consumer privacy should be in a region and you're submitting something. So that's kind of the process.
Awesome. We're actually getting a lot of great questions here. So Keys is asking, do you have a suggestion on how to decode the GPP string to report at scale privacy choices from ad server impression logs? That one's in the chat, Rowena.
Oh, it's in the chat. I was looking for it. I was like, where is the... Do you have a suggestion on how to decode GPP strings to report at scale privacy choices from ad server impression logs? Report at scale privacy choices from ad server impression logs. I guess like my question back is like what does one mean by report at scale privacy choices from ad server impression logs?
You can see Keys is typing, so we'll see what he says.
We do have a separate specification at the Tech Lab that we call the accountability platform, that's meant to sort of observe strings. I'll say broadly strings, like they're not specifically scoped to GPP strings, and ensure that they're being appropriately propagated throughout the supply chain. For instance, the US privacy string was clear text, so opt-in with, oh, gotcha. So in the legacy US privacy string, it was human readable to a certain extent, so one YYN, but now GPP string is not clear text. Well, I would say that that it is an encoded string in GPP moving forward. So there is like a little bit of there. I shouldn't say little. That's like famous last words for engineers. But like there is an added level of complexity to the new strings. But again, they are more complex compared to the original like CCPA. CPRA amended it, and hence like additional complexity. We do offer at the Tech Lab open source uh, tools by way of like code libraries is one thing to help with the decoding implementation. So hopefully keys that can help. The idea there is that you can use some of the libraries to help with implementation.
Cool. Perfect. All right. It looks like we got a couple more questions. For CMP publishers currently using TCF or US privacy strings, what's the transition timeline or guidance on how to move fully to GPP?
Great question, Gregory.
We're waiting for that one. Where's the Rowena?
Great question. So for US privacy string, I'll start with that one because I would say that US privacy strings is easier. US privacy strings deprecated since January of 2024. So I would say transition timeline is to move to GPP for the US now, yesterday, if possible. If you can go back in time and do that, I would say do that piece immediately. For TCF version 2.2 and transition to GPP, we don't have a defined date of transition just yet. The Tech Lab, we work very closely with IAB Europe, who's the managing organization, and for TCF participants, like you guys have to go through certain compliance requirements, and there's no mandate, right, to start making use of GPP TCF Europe strings at this point. So there's no mandatory timeline yet, but again, we are hoping to kind of move folks at some point in time in the future. And so I know that there are folks who are starting to test GPP TCF Europe in anticipation of that. And so, I know it's hard to find bandwidth on roadmaps, but I would encourage that if bandwidth allows for it. But there's no hard timeline just yet for TCF Europe in GPP.
I think there's two other questions. I think they're actually somewhat similar. And so should GPP have just one set of consents? In EU, just GDPR, and California, just CCPA, or should we have them all, or should we have all of them if possible for each user?
I laugh because this is another hairy one. I don't know, Jeff, do you want me to?
Well, I mean, I think it's it's always like the general consent question of like, do you have to reconsent every time someone travels somewhere else? And I think what we typically see, and again, like neither of us being lawyers, I can tell you like what most of the industry does is it's impossible unless you're using authenticated users to know like where they're from. Are they a California resident? Are they a Utah resident? Are they a French resident? Are they, an Irish resident? Whatever. And so I think like the guidance that we've kind of heard and talked about is you take your interpreted approach. And so like for a lot of our EU customers, they rely on that GDPR banner, and if someone is consented to their site in Europe and they go to California, like they're not ever like going to redisplay the banner asking for consent in California because they're visiting California. Those are like they're such edge use cases that it's been really hard to do that. So from like our point of view, what we typically recommend is you just offer that initial use case of wherever they consented to based off their first time seeing the banner, like that's what you recognize, and then of course they can go in and change their choice later on. From a UX perspective, it's also not the best policy. It's rough on the consumer if you're bombarding them with consent banners every time they change their location or region. And so, I think to answer that question from like my point of view, is it should probably just be the consent that they were originally given. And if they reconsent, maybe in a different regulation, that's a use case to kind of address down the road. But I would just I would go down the path of wherever your business is based out of, or wherever they first consent. That's typically the consent string that's probably they're going to consent to and should be built.
Yeah, and my answer, like, I would always start off with, like, you should actually ask your legal teams,
Yeah.
because we are not lawyers here, Jeff, you and I, and the one, like, addition to your answer, Jeff, that I would say is that from like a GPP standard perspective, there is like a level of flexibility. So, to like allow folks to determine what is the best path forward for them, in that um, the GPP, there is something called like applicable section. So you can always define like what is in scope for this user at this time, and then like how you get there is up to you know up to you guys.
So I think we had a couple more frequently asked questions, just as we have a few more minutes, Rowena. I think this next one is we've kind of touched on it a little bit, but how does GPP also support other privacy signals how does GPP also support other privacy signals such as GPC? And just to be clear, GPP, Global Privacy Protocol, GPC, Global Privacy Control, which is a standard set by a few of the states, in particular the California Privacy Protection Authority that's enforcing the law there.
Yeah. So, I mean, to like start off, I would say that we need to stop introducing new privacy signals, is what I would say. That's what is making it really, I would say, generally like hairy for the industry. And so obviously being at Tech Lab, I'm going to advocate for GPP, and if there are issues with GPP, for folks to please voice them so that we can continue to improve upon them. The difference between GPP and GPC, I would say, is that GPC it's also a technical standard. It is essentially an opt-out signal at the browser level that is stewarded by the W3C, but it is an a universal opt-out mechanism that is recognized in multiple US states as something that must be respected and accepted as the consumer making a choice and telling you that they would like to opt out of the cell or share their information. And so the way that we support that in the GPP, because that's a little bit different, right? A universal browser level opt out mechanism is different than what the GPP signal is, which is, I would say like more website or an individual website level, is that we carry that as a portion of the string in the US states, where they've explicitly called out the requirement to respect universal opt out mechanisms. So wherever there is a state that says like you must respect universal opt-out mechanisms in the GPP strings, you can include that as well, and you will be able to see that.
And obviously, like from like the CMP point of view, right? Like we will also support universal opt-outs such as GPC, with a consent banner or option there as well, right? So, most of the time what we see is they're on more of the we see it more on the browser level, but for instance, there are a handful of extensions in Chrome, for instance, that can trigger a GPC signal. So, you could in theory write that, recognize that GPC signal and have that flow downstream and write that to a string if you wanted to. Those are options, but that's kind of this is kind of where I think it's important to reemphasize why just implementing GPP requires support from like a CMP to help kind of coordinate that, and the CMP's job is to reinterpret those signals and pass those, to help pass those signals as well and create those signals. So, it's definitely a relationship between, us and Tech Lab or any other CMP that's working with Tech Lab to make sure that we're supporting these signals to make that user choice respected, up and downstream. And I think this actually this kind of ties into another question that Marco just offered. And I can take kind of the first crack at it. Rowena is GPP offers the ability to manage multiple privacy laws and is certainly an excellent solution for CMP developers. I want to know if it's defined on how to choose whether to display a privacy law to an end user using IP geolocation. From my end, Ray, keep me honest here, right? But GPP isn't looking for, like they're not looking for the user to be at a location. What's typically happening here, and this isn't going to be unique to Didomi, is the CMP is going to provide the mechanism to serve said law, right? So, most CMPs will use a cloud provider to geolocate using like an IP address, something like CloudFront or the equivalent in Azure or whatever, and that's typically how they'll say, hey, this user is from New York, and they would get the relevant law that's set up within the CMP, and then the CMP translates that into a GPP string that's created. And that can also be manipulated. And if you're talking about the difference between an authenticated user or an anonymous user, if you're serving consent based off a user database, where they're from, and you can typically override that like IP geolocation to whatever location is being sent. And then it's our job as Didomi to implement and build the string in the correct way based off the GPP spec.
Yeah, so I guess like that's typically what I hear as well, Jeff, for a lot of like implementations. IP address is most common unless the first party or the website owner has, their own like detail about the consumer. And I say like detail about the consumer, and so like GPP is not prescriptive on how to determine like ultimately which law should apply in which case. And I say like specific information about the consumer because the other like tricky thing, and this is like where the nuance of global privacy regulations come into play, is some of the regs say that these rights are afforded to just residents of this jurisdiction. Some of
Yep.
the other laws actually don't say it's afforded to just residents. They actually say it's afforded to anyone who's physically here. And so like even that this piece is very hairy, and that's why there are, I would say, like different mechanisms that folks might use, that I've heard folks might use in determining which ultimately like which law should apply. And so we're not prescriptive in the protocol itself on how to do that.
Yeah. I think people are reading our minds. We're getting a lot of questions that tie really well into the next one. So I'm gonna read Camille's question. So GPP string will be checked by ad networks and other players. If I have a GPP string for a user that was gathered in the EU, while he or she accesses the service from the US, will the ad network assume that this user must be from the EU, and will they consider GDPR as valid for him or her?
This is the US, or like I would say like GDPR in Europe plus any other jurisdiction is always like a question, because there is like a very funny thing in GDPR that also says like if the business is I forget exactly what it is, but it's like if they're incorporated in Europe, then GDPR applies.
Mm-hmm.
And this is what trips like a lot of people up. And so um, what GPP allows for is in our specs, we actually say you can actually state, like, depending on your interpretation, again, consult your legal teams here, but like it allows you to say that up to two sections or jurisdictions can apply at once. And it is for this exact case. The reason why we allowed for saying that up to two jurisdictions laws could be applicable at the same time is because it's like one of the impetus for reasons for it is because there is this like interesting scenario where like GDPR, some folks will say like I am a business in Europe and therefore GDPR always applies to me, even if the consumer is in California. So this is like I think this is one of those things where engaging with partners is really important. But it does like allow you to send both. So I can't speak to like what the ad network would assume. It differs. It differs.
Yep, for sure. Great, everyone. Well, I think that is it for the questions that I'm seeing. We've got a few minutes left. I think we'll wrap up a couple minutes early. Rowena, thank you so much. I think this is immensely helpful to start to straighten out some of the misconceptions around GPP. If you guys do have any more questions, feel free to reach out to any one of us. On the call, or if you're working with Didomi in particular, feel free to reach out to your CSM. And thank you again for joining. If you have any other feedback, please let us know. And if not, have a great day.
Thanks, Jeff. Thanks all.